Peng Shuang suffered a fatal allergic reaction after eating at a Disney Springs restaurant last fall, and an EpiPen wasn't enough to keep her alive.
She was basically ripped from our lives, and it's a tragedy.
Peter Giattino speaks on behalf of Piccolo as his cousin and one of his attorneys. Months after filing a lawsuit, Walt Disney Parks and Resorts is now trying to get it tossed because Piccolo signed up for a 1-month trial of Disney Plus.
I think that's crazy.
The fine print mandates users settle any lawsuits out of court through arbitration.
This was the ultimate loss from Jeffrey. She was stolen from him. And now, in effect, what Disney's doing is trying to steal his day in court.
Lawyers for Disney are trying to get a wrongful death lawsuit thrown out of court, and their reasoning has to do with reading the fine print. Glad you're with us. I'm Lisa Bell.
And I'm Ginger Gadsden. This is News 6 at 4:30, getting results. Now, according to the lawsuit, a doctor and her husband were dining at Disney Springs. She told the staff at Raglan Road she had a severe allergy to dairy and nuts and was reassured her meal was safe. 45 minutes later, she suffered a severe allergic reaction and died at the hospital. Her husband sued the restaurant owners and Disney. Disney has released a statement saying they are deeply saddened by the family's loss and understand their grief, given that this restaurant is neither owned nor operated by Disney. They say they are defending themselves against the plaintiff's attorney's attempts to include them in their lawsuit against the restaurant.
You know, there comes a time in every lawyer's career where you have to make what you know is a bad argument, but maybe it's just the best one that you have, or maybe it's the one that the client just really wants you to make. That seems to be the position that the Disney lawyers are finding themselves in right now for this wrongful death lawsuit that was filed earlier this year. And now Disney's in some hot PR water because the public is rightfully pretty outraged about it. And to be honest, it's really not a great legal argument either. Essentially, Disney is trying to get this lawsuit taken out of the normal court system and placed into arbitration instead. In this video, we're going to go over what all of that means and why Disney is making this argument and why I personally think it's a losing argument and therefore essentially a lose-lose situation for Disney overall right now. Let's get into it. Okay, so first let's go over all of the important factual points here before we get into Disney's legal arguments. Like I said, this is all over a wrongful death case. Dr. Kanakporn Tangsuan was on a vacation with her husband Jeffrey Piccolo at Disney World down in Florida in October 2023. One of the nights that they were there, they decided to dine at Raglan Road Irish Pub and Restaurant. And apparently she had a known food allergy. She was apparently deathly allergic to nuts and dairy. And according to the lawsuit, she apparently made it very well known that she had this allergy and that she really needed to be sure that she wouldn't come into contact with those allergens by eating their food. And despite all of the assurances that they got from the restaurant's website and from the restaurant itself, 45 minutes into this dinner at Raglan Road, she had a severe allergic reaction. And despite immediately using an EpiPen that she apparently carried with her everywhere, she ended up unfortunately dying from this allergic reaction. So her husband is suing both the restaurant and Disney. And importantly, he's not suing on his own behalf. He is suing as the executor of his wife's estate. And that's an important detail, and we'll get into why that is in just a moment. But first, I want to point out a couple other important details here. For one thing, Raglan Road is apparently not a Disney-owned restaurant. They are entirely independent of Disney. However, the reason that Disney got pulled into this lawsuit is because Raglan Road is apparently situated on land owned by Disney. Specifically, this was in the Disney Springs area of Disney World. Now, initially, I wasn't familiar with Disney Springs since I've only been to Disney World once in my life. But being from Southern California and being very familiar with Disneyland and the parks around there, it sounds to me that this is something similar to Disneyland's downtown Disney area. So if you're from Southern California or you're just familiar with this part of Southern California, you have that as a reference. But even if you're not, essentially it doesn't require a ticket into any of the parks to access this area. Basically, you can just drive in, park, and then go to dinner at any of these restaurants in this whole area. So Raglan Road is sitting on Disney property, but it's not like it's inside Epcot or the Magic Kingdom or any of the other parks that actually do require a ticket for entrance. And so that's how these various people and entities relate to one another here. Now, another thing that I do want to clear up here is also this detail about the estate suing for $50,000. Based on the reporting by the media about this detail, I think a lot of people see that number and have the impression that that is all that the estate is suing for. But $50,000 is actually just a jurisdictional threshold to have access to Florida's circuit court. And what I mean by this is that Florida, just like a lot of states in the US, has a number of different types of courts depending on how much is being claimed in damages by the plaintiff. Most people are probably familiar with the idea, at least, of small claims court. That's one example of what I'm talking about, where you're only suing for a very small amount, so you're going into this specialized kind of court. Anyway, in Florida, you apparently have to claim damages of at least $50,000 in order to get your case heard in the circuit court, as opposed to, say, the county court or the small claims court. So what they're talking about here is at least $50,000 in damages. And based on the fact that we are talking about a death of a human being here, and apparently one who was also an NYU physician with a high earnings potential, we are talking more about millions of dollars of damages here, most likely. So as you can see, the underlying facts of the lawsuit are actually pretty straightforward. We have a wrongful death case here over essentially an allergy poisoning from a restaurant that is located on Disney's property. Now let's get to the part of this whole situation that has people really up in arms: Disney's legal arguments. So what Disney is trying to do here is move this whole lawsuit into arbitration. If you're not familiar, arbitration is a form of alternative dispute resolution, or ADR for short. Anytime you hear about arbitration or mediation, these are types of alternative dispute resolution. And despite what some people will say, they're not really inherently evil. They can actually serve a really good function in the overall American judicial ecosystem. You see, because American courts are typically so backed up with cases, and because litigation is so expensive, courts will often encourage these parties to resolve their disputes between each other in these alternative ways. And in fact, Congress passed the Federal Arbitration Act for this very purpose as well. And this is one big reason why the vast majority of civil cases will actually end up in some kind of a settlement between the parties. But arbitration is a particularly interesting one. It's when the two parties, like I said, they take their case out of the normal court system and they put it in front of an arbitrator who makes an ultimate decision about who wins and who loses. An arbitrator is essentially someone who sits in the same position as a judge would in a normal case. And very often, arbitrators actually will be retired judges. It's also often the case that an arbitrator will use the very same rules of evidence, or something very close to them, that a normal judge would use in a normal court case. But without getting too deep into it, arbitration has its advantages and its disadvantages. And for example, disadvantages include the fact that they are losing their right to have this trial decided by a jury of their peers. But big corporations like Disney generally love to have as many of their disputes handled in arbitration as possible. Okay, so that's what arbitration is. Why does Disney say that a wrongful death claim from an allergic reaction should be handled in arbitration? A lot of the reporting on this whole situation has been focused on the terms of use for a Disney Plus subscription, but Disney actually makes a number of arguments. The first is, like I said, that because Jeffrey Piccolo, the man who is bringing this whole lawsuit, because he once signed up for a 1-month trial period of Disney Plus, that he agreed to arbitration for all disputes with Disney, basically on anything until the end of time. Then Disney's second argument is that Jeffrey Piccolo also agreed to arbitration when he signed up to use the My Disney Experience app to buy tickets to the Disney parks. And so, in Disney's motion to compel arbitration, which is where all of these arguments are coming from, Disney spends a lot of time talking about how Piccolo for sure agreed to all of this and that it doesn't matter whether or not he actually read the terms of the arbitration agreement. And that's all fine. That's common argument for these kind of arbitration agreement disputes and motions to compel arbitration. And there's actually a lot of case law to support that kind of an argument. But here's where we can just start to scratch underneath the surface a little bit and to show why Disney's argument is actually a pretty weak one. I mean, of course, you don't need a law degree to conclude that their argument here is both stupid and just completely bananas. But sometimes when we talk about these cases, there can be a difference of opinion depending on whether you are looking at it from the perspective of a layperson or a lawyer. For example, a layperson might look at the fact that the U.S. Olympic and Paralympic Committee trademarked words like Olympian and Olympic and be like, that's absolutely outrageous. How can they do that? These words have been in existence since like forever. ever. But then a lawyer might look at the same situation and say, well, here's why it's actually not all that ridiculous, because there's all these kinds of nuances and those kind of nuances, and here's how everything works. But this is a situation where I think even looking at this from a lawyer's perspective, it's really not a great argument. To explain why, we've got to go a little bit deeper for a minute, and bear with me because we're going to get a little bit into the weeds, but it'll be worth it, I promise. So Disney points to a number of what we call click wrap agreements that Piccolo apparently entered into. When I say click wrap agreements, I'm talking about those long pop-up texts that show up when you either download new software or you sign up for a subscription service where you need to sort of scroll down this wall of text and then click a single button that basically says, I agree. Everyone has seen those at some point or another. They're everywhere and basically no one reads them probably. And of course, they are totally legal. And in this case, Disney says that Piccolo agreed to the terms in several different click wrap agreements. One was through his use of Disney Plus for a 1-month free trial, and another was for the My Disney Experience app that he apparently used to buy Disney World tickets. Then there's also a terms of use that was referenced in one of these agreements and therefore incorporated into the agreement, and Disney says that Piccolo is subject to that one as well. And Disney says that all of these agreements actually bind Piccolo to arbitration for any dispute between him and Disney. This is, of course, the thing that has everyone up in arms over this whole story, and justifiably so. It is wild to see a corporation that is as big as Disney basically say, hey, because you use this one service over here and because you click this tiny little button while doing that, anytime you have a dispute with us in the future over literally anything, at any point in time in the future, you're going to have to use arbitration. It sounds very much like, you check this box and all of a sudden you've sold your entire soul to this big corporation. It's just a really broad power that Disney is asserting over everyone, and it feels very manipulative and greedy. But here's the thing. Disney says that these click wrap agreements say that any disputes between Piccolo and Disney have to be done in arbitration. But what Disney is, of course, hoping that the court doesn't pay attention to is the fact that all of these click wrap agreements have definitions for what counts as a dispute that falls under these arbitration agreements in the first place. And if you look at the actual language in these arbitration agreements, they define these things in a much more limited way than what Disney is arguing now in this lawsuit. For example, let's look at the arbitration clause language that is in the Disney Plus click wrap agreement. It says, you and Disney DTC agree to arbitrate as provided below all disputes between you, including any related disputes involving the Walt Disney Company or its affiliates that are not resolved informally, except disputes relating to the ownership or enforcement of intellectual property rights. So I will say, when you first look at this, it looks like, okay, this actually does look pretty broad in its language. It says all disputes here. However, an important part of any analysis of any contract, including in arbitration agreements, because these are contracts, in fact, is you have to read these things in their greater context. This means not just reading the specific phrase or the specific sentence, but also reading around that to show what people are actually looking at and understanding when they are agreeing to it, whether or not they've read the thing. And so in this case, if you read just a little bit further in this arbitration clause, you can see that they define the word disputes. Here it says, dispute includes any dispute, action, or other controversy, whether based on past, present, or future events, between you and us concerning the Disney services or this agreement, whether in contract, tort, warranty, statute, regulation, or other legal or equitable basis. So basically, to take that out of legalese and put it into normal English, that basically means you agree to arbitration for any argument between you and Disney over either this particular agreement, meaning the click wrap agreement itself, or over Disney services. And note that Disney services is capitalized D, capitalized S. So this is definitely going to be a specific term that they are going to be defining. So then, what does Disney mean when they talk about Disney services under this agreement? Here they say that Disney services is defined in the agreement as sites, software, applications, content, products, and services. And they say that this includes Disney's website. So what does all of that mean? That means that by clicking the I agree button to test out Disney Plus, Piccolo agreed to have any dispute between him and Disney over Disney services, aka sites, software, applications, content, products, and services sent to arbitration. So then we have to ask, is this case, the current case that we are talking about any of that? Is Piccolo suing Disney over sites, software, applications, content, products, or services? No, of course not. He's suing as the executor of his wife's estate over her wrongful death when the restaurant fed her deadly allergens after ensuring her that they didn't use any nuts or dairy in the food that they were serving her. And so that's obviously completely unrelated to anything having to do with Disney Plus. And on top of these things being two entirely different situations, you have the fact that Piccolo tried out Disney Plus on his own behalf. But in this case, he's not suing Disney and Raglan Road for himself. He's acting as the agent of the estate of his wife. He's the executor of her estate, and that is a big difference too. Her estate had nothing to do with her husband independently deciding to try out Disney Plus for a month. And so that is yet another reason why this argument is total junk. So that's the Disney Plus argument, which as you can tell isn't a great argument when you start to scratch just below the surface here. And the thing is, the same thing is basically true of the other agreements that Disney points to in their arguments for why this should go to arbitration. For one thing, they argue that the Disney Plus click-wrap agreement also brings in Disney's terms of use agreement, which also has its own arbitration agreement. And that is on its own a very common thing. You see this all the time with social media platforms, for example. But even when you look at the language in Disney's terms of use, Disney runs into the same problem here. Here you can see that the Disney terms of use covers Disney products. Capital D, capital P. This is another term that is specifically defined. And they define Disney products as certain websites, software, applications, content, products, and services in any media format or channel now known or hereafter devised. In other words, it covers all the Disney websites and apps and streaming services and other tech media kind of stuff. There is absolutely nothing in this that is talking about anything having to do with being physically present at any of the Disney parks or on any kind of Disney real estate property. So this shouldn't have anything to do with this case about a woman dying from something bad happening on Disney property. So that's that for the Disney terms of use argument. The way I see it, it's another fail for Disney here. So then we turn to the third argument, the My Disney Experience app argument. And as far as I can see, this fails for the same reason. This was apparently the app that Piccolo used to buy the tickets for him and his wife to enter the Disney parks. And Disney points to the part of the terms and conditions for the app that says, by using the site/app or by clicking a box that states that you accept or agree to the My Disney Experience terms and conditions, you signify your agreement to these terms for yourself and for all persons for whom you are purchasing tickets. And so, Disney says, he agreed to this arbitration clause there as well, and so this has to go to arbitration. And I will say, this argument gets a little bit closer to success, but not quite. Because this arbitration clause says that it covers disputes for all people for whom you bought tickets to the Disney parks. And here, Piccolo apparently did buy tickets for himself and for Dr. Tangswan, the decedent, into the Disney parks. But again, we have to ask, what is this dispute about? Is this dispute about something that happened on Disney property? Yes. But is this dispute about something that happened on Disney property that requires buying a ticket for entry? And the answer to that is a big fat no. Remember, the wrongful death claim comes from an allergic response to food that was served at Disney Springs. Disney Springs does not require a ticket to get onto the premises and enjoy a restaurant scene. Any old person who happens to be in Orange County, Florida can just drive up, park their car, and go to dinner there. So this dispute does not arise out of a ticketed Disney experience. And so this means the arbitration clause, which covers disputes arising out of things having to do with the purchase or enjoyment of these tickets, shouldn't apply here. The fact that Piccolo and Dr. Tangswan also happened to buy tickets should not make any kind of a difference. And so all of this brings me back to saying that this whole arbitration argument between Disney and the Tangswan estate puts a bad taste in the mouths of a lot of people, and it is totally justifiable. Often, lawyers have to make the best argument that they can make, even though they know that it's not a good argument, and even when they realize that they're going to have to look pretty bad in order to make it. But in a case like this, there had to be someone, either at Disney or at the law firm that's representing them, that was going to take a step back and evaluate the costs and benefits of making this kind of an argument. Obviously, we are looking at two different courts here at the same time, as we often see in these kinds of cases that we talk about on this channel. There's the court of public opinion, and then there's the court of law. In the court of law, they have to consider how strong an argument is and whether it's worthwhile to try to make it. They also have to consider that maybe not making an argument could waive some important rights sometimes. But sometimes you can also make an argument by filing a motion to do something, but if you know that it's very, very likely to fail, you can end up billing client for hours that you pretty much know are going to be a waste. And as lawyers, we do have a responsibility to treat client funds responsibly. On the other hand, sometimes a client will also say, I want you to take absolutely every possible opportunity to win for me on this particular issue, no matter how strong or weak the argument is. And so sometimes lawyers have to make an argument that they may or may not actually believe in. It happens a lot, actually. But hey, maybe there's some kind of a chance that it might work out. Maybe it's a Hail Mary pass. Anyway, then there's the court of public opinion. And in the court of public opinion, they have to consider the PR consequences to making some kind of an argument like this. Like here, if it gets out to the general public that Disney, a huge mega corporation, is trying to axe a lawsuit where a woman died on Disney property, and they're trying to do it with a weird argument that points to just how powerful and all-consuming the corporation is, will we see blowback for that? And so basically looking back at both of these types of courts, right, the court of law and the court of public opinion, I think both of these give reason for Disney to not take the particular course of action that they decided to take. Because overall, it just looks super scummy. It's like a stereotypical David and Goliath story, but where Goliath isn't just a giant, it's a giant that has tentacles that are trying to spread to every aspect of a human's life. And really, this is just one reason why there are so many people who hate lawyers. And personally, I hate to see that. Because there are plenty of good lawyers out there doing really good work for their clients in a way that is helping to bring about justice and recompense and all kinds of good things in this world. But those are my thoughts. What do you think? Are you outraged by Disney trying to use this argument to shoehorn this case into arbitration? Do you think that Disney has a decent argument as much as people might hate to see it? Is there something that you think I may have missed or gotten wrong here? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more crazy cases and interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out there. And if you're really enjoying the content and you want to know how to best support the channel and get perks like early access to videos like this one, consider becoming a member of Byte Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you in the next one.